Thank you. Again, my name is Brian Tuttle, and I've been doing this, doing compliance consulting for about 15 years. There's been an awful lot of changes the last few years with some new laws going into place. I've been contacted multiple times and been serving on a lot of court cases lately where, as expert witness, because individuals are learning that they have the right of remedy under HIPAA, meaning they can sue under state law and get paid via the federal HIPAA law. So this is causing a lot more stress on folks. The federal government is now proactively going after covered entities and business associates regarding non-compliance for HIPAA as well. And I've done, gosh, probably 400 to 500 risk analysis throughout the United States for both covered entities and business associates as well. And there's just a lot going on now, and this law is no longer benign like it used to be. So without further ado, I'll jump into this because we've got quite a bit to cover here. I'm not going to spend much time on history, but I just want to go through what HIPAA is, what brought it about. It's known as the Health Insurance Portability Act. It was enacted by the U.S. Congress and signed by President Clinton back in 1996. And quite frankly, from its inception, it didn't have anything to do really with privacy and security of health information. And when most folks think about HIPAA, you think, be quiet, don't disclose PHI, don't wrongfully disclose PHI, don't lose PHI, keep everything encrypted, don't email PHI, so on and so forth, all about security, but there's a lot more to this law than that. It's just that privacy and security are our biggest challenges by far. It's also known as the Kennedy-Kasselbaum Act, named after its two major sponsors, Ted Kennedy of Massachusetts and Nancy Kasselbaum of Kansas, one a Democrat, one a Republican, so we can blame both parties for all of this fun here. The acronym is the Health Insurance Portability and Accountability Act of 1996. And as you can see, once again, the words privacy and security are not mentioned in that acronym, but privacy and security are our biggest challenge again. One thing about what's going on as well is the government is being proactive in the auditing, where in the past they were reactive. The government would very rarely audit any covered entity or business associate unless there was a reason to do so. But that has changed, and they outsource the auditing to people like myself and any other firms, for example, that are dealing with this to make sure that the auditor goes in and kind of has a vested interest in levying fines or finding things wrong with this, because you lose the contract if you don't find any issues. So it's a huge catch-22, and it's not really fair because HIPAA is not explained well. A does not equal B. There's no such thing as 100% compliance. It's all based, and it's subjective. It's all based on taking reasonable and appropriate risk mitigating steps. But what does reasonable and appropriate mean? The government tells us what to do, but not how to do anything. So it makes it extremely frustrating. And having the inside knowledge of what is looked for in an audit is good, because I'm coming forth and bringing this information from also the auditor's perspective as well as the practices or the business's perspective on what needs to be done. Okay, so a little bit more about what HIPAA is. You notice there's 5 titles here. We have Title I being Healthcare Access, Portability, and Renewability. Title II, Preventing Healthcare Fraud and Abuse, Administrative Simplification, Medical Liability Reform. And you notice that Administrative Simplification is in red. The reason that is in red is because it's under this subset of Title II where we find HIPAA privacy and security, as well as coding, ICD-10 or ICD codes, and so on and so forth. That's the area of the biggest struggles, is under this one little part of Title II being being privacy security, and the coding moving to ICD-10, which I'm not going to get into that. That's a whole different thing. But it's just one little part of it that tends to be the biggest struggle with folks. Title III, tax-related health provisions. Title IV, application and enforcement of group health plan requirements. Title V, revenue offsets. Okay, so let's move